Hey business owners, on June 28, 2024, the Supreme Court made a decision that could save your business thousands in compliance costs, or cost you even more if you don't understand it. I'm Michael Sterling with Compliance Made Clear, and if you want weekly updates on regulations that affect your business, hit that subscribe button right now. Quick disclaimer, I'm not an attorney and this isn't legal advice. I'm here to break down complex regulations so you can have informed conversations with your legal team. Think of me as your compliance translator. Now, let's talk about this Supreme Court decision like you're 10 years old, because that's how all laws should be explained. Imagine you're in 4th grade and your teacher gives you homework that says, write a good essay. But what does good mean? For 40 years, when government agencies like OSHA or the Department of Labor weren't sure what a law meant, judges would say, hey, you're the experts. You decide what it means. It's like if every time your teacher wasn't sure about the homework rules, they let the principal decide. And whatever the principal said, everyone had to follow, even if other teachers disagreed. Well, the Supreme Court just said, nope, that stops now. The case was called Loper Bright Enterprises versus Raimondo. Don't worry about remembering that name. Just remember what it means for your business. Before Loper, government agencies got to interpret unclear laws however they wanted, and judges had to go along with it. After Loper, judges now get to decide what laws mean, not the agencies. Think of it like this. Instead of letting the principal make up homework rules, now the teachers have to figure it out themselves. And if they disagree with the principal, the teachers win. So why should debt settlement companies, credit repair businesses, and financial services care about this? Here's the real talk. First, more lawsuits coming. Every agency rule that seems unfair or too aggressive, someone's going to sue now, and they have a better chance of winning. Second, OSHA rules are vulnerable. You know those workplace safety rules that seem to come out of nowhere? Like the new heat stress rules? Those can now be challenged in court much easier. Third, Department of Labor Overreach. Remember when they changed the Davis-Bacon Act rules or increased salary requirements for exempt employees? Those types of interpretations are now prime targets for lawsuits. Fourth, NLRB decisions. All those expanding union rules and protected activity interpretations, they're not as bulletproof anymore. The bottom line, agencies can't just make up what they think a law means anymore. They have to prove it's the only correct interpretation. Here's your action plan. And remember, discuss these strategies with your attorney. If you're dealing with a questionable agency ruling, don't just accept it because that's what the agency says. Consider having your legal team evaluate potential challenges. Look for cases where others are challenging similar interpretations. If you're planning compliance strategies, expect more court battles over agency rules. Don't assume today's agency interpretation will stick forever. Focus on what the actual law says, not just agency guidance. The 10-year-old explanation. When your mum says clean your room, she can't later claim that means also do your sister's laundry, just because she's the mum. The words mean what they mean. Let's get specific. TCPA enforcement. If the FCC tries to expand what counts as an auto dialer beyond what the law clearly states, that's now challengeable. Debt collection rules. If the CFPB interprets the FDCPA in ways that seem to go beyond the actual text, courts don't have to defer anymore. State licensing issues. While this is federal, expect similar challenges to state agency overreach. Heat stress rules. OSHA just proposed new heat rules in July. Under the old system, if the law was unclear, OSHA's interpretation would likely win. Now, not so much. Look, this doesn't mean agencies can't make rules. They absolutely can. But now they have to stick to what Congress actually wrote, not what they wish Congress had written. Your homework. Review any recent agency actions affecting your business with your legal team. Ask, does this rule match what the actual law says? Or is this the agency adding their own spin? Now here's what I need from you. Drop a comment below and tell me, what agency rule have you always thought was overreach? What compliance topic should I tackle next? Have you seen any agency interpretations that seem to go way beyond what the law actually says? Your comments help me create content that actually helps your business. And if this breakdown was helpful, smash that like button and subscribe for weekly compliance updates. Next week, we're diving into how this affects TCPA compliance specifically. You won't want to miss it. Remember, complex laws, simple solutions. I'm Michael Sterling, and I'll see you next Tuesday. Keep those comments coming.